The word is only 7 letters. Refused. You see it in an AMI message late at night. You read the notice once, then again. You still cannot tell whether the decision is final, whether you can respond, or whether a deadline started before you even understood what happened. One applicant wrote in an online expat forum, "AMI refused my application, but I do not understand why, and my appeal deadline is already running." That is the moment when panic tells you to write an angry appeal, search for a deadline online, or wait for somebody to explain. My position is simple. Do none of those things first. Classification comes before outrage. Proof comes before volume. A refusal is the moment to preserve your options.
Welcome to Portugal Writes Rebel, episode XML. I'm Elena Vargas. Today, we tackle one of the most common nightmares expats face in Portugal and show you how to respond legally and effectively. We will identify the document, reconstruct notification, protect the timeline, prepare evidence, and examine the routes that may need to be discussed with counsel. We will also be honest about limits. Not every refusal can be overturned. An online complaint is not automatically an appeal. An EU complaint is not an emergency court filing, and compensation is never automatic. This episode is general education, not legal advice. The exact remedy, deadline, and filing requirements depend on your decision and your facts, so consult a qualified Portuguese lawyer promptly. Before you write a single sentence of an appeal, let me stop you. What exactly did AIMA send? A portal screen that says refused may not tell you whether you received a final refusal, a preliminary negative notice, a request for missing documents, a cancellation, an archiving decision, or a notice that the process expired. Those events can have different consequences and different remedies. Find the complete notice, every attachment, and any page that identifies the authority, date, reasoning, reference, and available response. Save the original file exactly as received. Then make a copy for notes. Do not argue with a label when the legal document may say something more precise.
Now reconstruct notification. Record the channel, the account or email used, the date and time shown, the moment you accessed the document, and any envelope, delivery, or registered mail information. Save screenshots, portal history, emails, and access records, but keep the full notice as your primary file. Here is why this matters. In an illustrative situation, an applicant opened a message on 14 May, while the record appeared to show that the notice had been made available on 10 May. That does not tell us what the legal date is. It tells us that the original notice and access history must be reviewed carefully. Never turn a forum answer into a universal deadline.
Create one page called What Happened. Put the application date at the top. Add payment receipts, appointments, biometric records, document requests, your replies, address changes, messages from AIMA, and the disputed notice. Beside each event, write where the proof is stored. Then create a separate deadline calendar. Put in the date you are currently working from, mark it as unverified, and contact counsel immediately to confirm the legally relevant date and remedy. Add reminders for today, the next working day, and the date your lawyer advises. The system is slow. Your preparation shouldn't be. Keep 2 files. The complete archive contains every page, email, translation, receipt, and failed upload. The lawyer-ready file contains the notice, your 1-page chronology, your current immigration position, and a numbered evidence index. Name documents consistently, using the date and a short description. If a portal fails, save the error message and record when you tried. If you submit something, preserve the receipt, tracking record, online confirmation, or stamped copy. A claim that you sent a document is much stronger when you can show how, when, and where it was submitted. Imagine the concern is accommodation. Do not stop at, "I live in Portugal." Show the lease, relevant payment records, registration evidence where appropriate, and a short explanation connecting each item to the issue. If the concern is income, identify the source, period, continuity, and supporting records. If family life is relevant, explain the relationships, dependency, practical consequences, and law status of the people affected.
Proportionality and family life considerations can matter in some cases, but they are not magic words. They become useful when connected to evidence and the legal framework. Ask your lawyer what translations or certifications are required, and preserve every original document. Here is a simple evidence matrix. 4 columns: the stated concern, your factual answer, the supporting document, and its location in the file. One row might say, financial means, lawful recurring income from employment, contract and recent records, archive, folder 2, pages 14 through 19. That is more useful than sending hundreds of unrelated pages and hoping someone finds the point. A strong response is not necessarily long. It is specific, respectful, indexed, and honest about uncertainty. Never alter an original document. Preserve it, then provide a readable copy or translation in the form your lawyer confirms. Once you know what decision you are facing, discuss the route. Depending on the decision and the governing rules, that might involve an administrative complaint, a hierarchical appeal where available, another administrative remedy, or an action before the Portuguese administrative courts. These are not interchangeable labels. The issuing authority, legal basis, notification, standing, requested outcome, and timing can all matter. A lawyer may recommend one route, coordinated routes, or no route you found in a social media template. The important point is this: do not spend the response period arguing about procedure while assuming the wrong document is being challenged. When you contact a lawyer, send the complete notice and the one-page chronology first. Ask 3 high-value questions. What is the legal nature of this document, and what event controls the timing analysis? Which remedies are realistically available, and what would each one seek? What evidence is missing, and what exactly is included in your fee and scope of work? A responsible lawyer should explain uncertainty. Be cautious of anyone who guarantees approval, promises a special connection inside an agency, or refuses to explain what happens if an urgent filing is needed. Consider 2 anonymized applicants. The first called a document a refusal. The lawyer asked, "Show me the entire notice." 2 pages later, the document showed an opportunity to respond before a final decision. The applicant preserved the notification, answered each concern, and attached proof that one previously uploaded document had not appeared in the case record. That organization did not guarantee approval. It changed the immediate task and preserved an argument about the missing record. The second applicant copied a generic appeal from the internet, attached an emotional statement, waited several weeks, and could not prove what had been filed or when. The applicant may still have had arguments, but the rushed strategy created avoidable problems. Emotion is not the enemy. Unstructured emotion is simply difficult for a decision-maker to use. You may be thinking, fine, I'll send a complaint to Brussels and wait. No. That may be relevant in a genuine European Union rights issue, but it does not automatically stop a Portuguese deadline. Solve It has a limited scope and may help with certain public authority problems involving internal market rights. A complaint to the European Commission can raise possible systemic non-compliance, but it is not a personal emergency appeal. EU free movement rights may matter in particular citizenship or family situations, but the facts must actually fit the applicable rules. National remedies remain a separate question, and a lawyer should help you decide what must happen first. The same caution applies to compensation. A refusal or delay does not automatically produce a payment. A damages claim generally requires separate analysis of unlawful conduct, actual damage, causation, evidence, and the correct procedure. Preserve proof of financial loss, canceled contracts, travel costs, and other impacts where legally relevant. But do not let a compensation theory distract you from the urgent step that may protect your resident's position. First, preserve the core rights. Then ask counsel whether a damages claim is realistic. Pause this episode and do 5 things today. Save the complete notice and attachments in their original form. Record exactly how and when you received or accessed it. Create a deadline calendar, clearly marking the dates that still require legal verification.
Preserve the entire application file, including receipts, translations, portal records, and proof of submission. Then send the notice and a focused chronology to a qualified Portuguese immigration or administrative lawyer. Do not post your documents publicly, and do not sign a statement you do not understand.
The refusal-response worksheet linked to this episode can help you capture the decision, notification history, chronology, evidence gaps, and questions for counsel. Use it privately. If you share lessons online, remove names, reference numbers, addresses, passport details, and information identifying children or vulnerable relatives. Anonymized experience can help another applicant recognize a problem. Personal documents belong in a secure professional channel.
So remember the central idea. The worst first move is to argue before you know what was decided. Preserve the notice. Classify the decision. Verify the clock. Build the evidence. Get qualified advice. Bureaucracy may be slow, but your preparation can make the process more accountable. Turn bureaucracy into accountability. Your rights don't disappear at the border.
Knowledge is your best defense. Document everything, act lawfully, and protect your future. Always consult a qualified Portuguese lawyer for your specific case.